I'm Dan Gelber, and I'm the former mayor of Miami Beach, and I'm also an attorney. And welcome to, the title of this is something to do with lawyers. But let's just, how many of you are lawyers? Okay, or married to one, it counts. How many of you are, I'll put it this way, are intentionally not lawyers? Yeah, there we go. And law students, you got at least, law student? Law student, okay, there we go. Yeah, the title of this is, as Shakespeare once said, first we've got to hire a lot of lawyers. Was that his quote? Okay. It's very close, it's very close. We're gonna talk, throughout this hall are lots of sessions on all the solutions that are out there and all the ways to track a path. I think this is the only session where you're gonna meet two incredible experts who are fighting the fight to not just try to convince people to do it, but try to force them through a court system that resolves issues and issues orders. And so I'd like to introduce you to first Andrea Rogers from our Children's Trust. And Andrea, just tell them a little bit about yourself and your organization, because we're going to talk about the cases that this firm, because it's a law firm, is doing. But first, I want you to know about how exceptional the people are and the organizations are that are carrying the water on this.
Thank you, Dan. Yeah, I work for an organization called Our Children's Trust. We are a nonprofit law firm, and we exclusively represent young people in constitutional cases against governments. So young people who've been harmed by climate change in a variety of different ways and who are seeking to protect their fundamental rights to a safe climate. We're a trauma-informed organization, so we as staff all have training in trauma-informed care, and we provide that training as well to all of our plaintiffs. They're working in a very difficult space, and most young people, when they have their first interactions with the court system, it's usually not in a positive place, and so we work to support them through the process as plaintiffs.
All right. Sam, Andrea's firm, your firm, and I call them law firms because they are law firms, and Earth Justice has one of the greatest slogans I've ever heard. What's the slogan?
Because the earth needs a good lawyer.
Right.
It does.
It's worth an applause. Andrea's, you have how many lawyers?
We have 210 right now.
You have 8, they have 210. So you're different in this space. But tell us a little bit about Earth Justice, which is probably the biggest environmental action law firm in America, in the world.
Yeah,
maybe?
It's the biggest environmental law firm that I know of anyway in the country. And it just happens to be a nonprofit law firm. We're about 50 years old, and for those who are lawyers and you remember that case, Sierra Club versus Morton, that you learned about in law school, it's sort of the original federal environmental law case, that was us. So we've been around for 50 years. There's 15 offices around the country, and we represent a wide range of folks, everything from concerned citizens to small, medium, large groups, including organizations like Our Children's Trust, some of the big greens and Natural Resources Defense Council, Sierra Club, but also utility ratepayers, industry associations like clean energy industry associations, and everything down to like fishermen's collectives, and you name it, huge range of laws.
All right, so let's just get into it, because instead of asking you a lot of general macro questions, let's look at this through the lens of some of your cases. All right, Andrea, let's talk. You've got a couple that are actually active in the court right now. Let's get to Held v. Montana.
Yes. Held versus Montana, we represent a group of 16 young people who live in Montana, all of whom have experienced a wide array of climate impacts, flooding, damaging their homes, cutting off their access, exposure to wildfire smoke. There's now a wildfire smoke season that prevents them from going to school and from participating in activities. And they brought suit against their state government, challenging the state's energy policy, as well as a provision of their Environmental Policy Act that explicitly directed agencies to ignore the effects of climate change when deciding whether to permit fossil fuel activities. Literally required them to turn a blind eye to what is probably the most important environmental issue facing the world today. This was the first case ever to go to trial, a climate change case going to trial. 14 of the 16 plaintiffs testified. and shared their story with the court and the world. It was really a remarkable experience to see these young people look their government straight in the eye, talk directly to the judge, and explain how their government has been harming them. The youth were supported by an incredible group of experts, all who donate their time pro bono. And this was an incredible, well-credentialed group, Nobel laureates among them. And they explained the climate science. We had pediatricians who testified about how young people, they described climate change as the single most important driver of children's health today. We had expert in mental health explaining how young people are really disproportionately impacted from the effects of climate change as they're growing up with developing brains and bodies. And then we had scientists talk about the emissions that Montana state government authorizes through their permitting and practices. The court issued a decision about a month after trial, wholly in favor of the youth, finding that there is a right to a safe climate that's codified and protected under the state constitution, and ordered the defendants to consider the effects of climate change when they're doing their permitting. And so there's really a substantive aspect of the decision in that informed decision-making means you'll get certain results. So now that's what we're briefing today, literally. Our brief is due tomorrow in the Montana Supreme Court, and we're hopeful that that decision will be upheld. The defendants only called 3 witnesses. So I think what's significant about the Held case is it shows that courts are not only capable of hearing testimony from the plaintiffs themselves and the scientific experts, but they're able to apply the law in the context of climate change, which has really been the holy grail in climate change cases, many of which have been unsuccessful over the last 40 years. So having a fully developed factual record that's largely uncontested at this point really benefits the case's chances at the Montana Supreme Court.
That's interesting. I mean, that's sort of amazing. How many people knew about this case? A lot of you know about it? I guess you have an audience that's pretty directed. Sam, you have your organization is large. It's got, I think, 500 or more active cases, or brought that many. What can the courts do? What do we get? Is it offense? Is it defense? In the Montana case, there was a clause in the Constitution that gave Montanans a right to clean air, I guess, and a clean environment. Not all states have that. What are the limits of the courts, and what are the possibilities, I guess?
In 2 minutes or less, right, Dan?
Or you can take 3.
Well, Montana is one of 6 states that has a constitutional provision, a state constitutional provision that guarantees, they're phrased differently, but a right to a clean and healthy environment. So that makes the opportunities in states like Montana, Rhode Island, Massachusetts, Pennsylvania, Illinois, and Hawaii, those are places where you can do this sort of thing. But in answer to whether the courts are a place you can play offense or defense, you can do both. Because in many cases you have to defend progress, whether that's regulations issued by government agencies that are often challenged by industries. That's a defensive thing that one does. And on the offensive side, you're often trying to enforce those laws against people, whether they're the government, people in the government, or people in corporations, or even just individuals, to do the right things in the law, or do the right things according to the law. What can you do in the courts? Well, the limits on what you can do in the courts are the things that courts are willing to do, which sounds circular, but that's because in our system of government, we have legislative branches, executive branches, and courts. And courts are typically very loath to do things that they think that legislatures are better positioned to do, or that governors, presidents are better positioned to do. So at least in this country, one of the major limits on what you can do is the limits on what our judicial system is willing to do.
Before we move back to Andrea, tell us a little bit about, we're in Florida, about the wetlands case that came out a year ago.
Sure. In fact, right in this room, I'm going to point her out, is Tanya Galoni, the lead architect of that case and the head of our Florida office. That's Tanya Galoni. I think the technical term for what she is she's a legal badass. She's the managing attorney of our Florida office. And in the waning days of the Trump administration granted to Florida the right to issue wetlands dredge and fill permits. That is to say, if you under the Clean Water Act, if you want to fill in wetlands, you typically need to get a permit. Now, side discussion of whether the Supreme Court and how much the Supreme Court has changed that, but usually that's a decision that the federal government makes. And in some situations, a state can say, we want that authorization to be able to do that ourselves without the federal government doing it. In the case of Florida, we were concerned, and many were concerned, that the state government might not implement the Clean Water Act in quite the aggressive way that it needs to be. And so we challenged the Trump administration's decision to do that because there are a bunch of legal requirements for a state to take that responsibility. And Tanya and her team recently persuaded a district court in Washington, D.C. to hold that the Trump administration had violated the Endangered Species Act, among many other laws, and we haven't yet gotten to all those other laws, violated the Endangered Species Act in doing it because it failed to follow the Endangered Species Act's requirements for making such a decision. So we've got a big initial victory, still talking about remedy, and I'm sure the case will be appealed, but it could not be in better hands.
And that's Florida, so it's not Montana where there's, I mean, it's...
It's under federal law, so that is, so...
Andrea, talk to us about the Hawaii case. I'm bouncing back and forth, but I think that perhaps looking at some of the general views through really the specific case itself isn't a bad idea. So go ahead and talk to us about Hawaii.
Yeah, Hawaii is a very exciting case because Hawaii is part of our, we have a domestic strategy and an international strategy and then a national strategy. And Hawaii is a key part of our domestic strategy. And we've partnered with the Hawaii Office of Earth Justice in co-counseling on this case. And there we represent 14 young people who are focused on challenging the state's transportation system. So transportation is really one of the hardest nuts to crack. I think if you look at emissions from transportation really are not declining. I think in a place like Hawaii, it has incredible laws on the book, including laws to decarbonize all sectors of the economy, including transportation. The electricity sector has made a lot of progress towards heading towards 100% renewable energy, largely because of the work of Earth Justice's office there. So you see a lot of progress in that sector. In transportation, you're not seeing the same progress. And to quote my co-counsel, Isaac Morawake, transportation is the flat tire in Hawaii. And so our case is designed to fix that problem. And so we have brought constitutional claims against the state of Hawaii and the Hawaii Department of Transportation for operating a transportation system that results in really high levels of greenhouse gas emissions. And the remedy we're seeking is a declaration that not only do the young people have constitutional rights that are at stake in that litigation, but that state government has an obligation to reduce emissions from the transportation sector. So that case is going to trial in June of this year. There'll be a 3-week trial. We have another incredible group of experts, including 2 Native Hawaiian experts who will be talking about climate science from both a Western perspective and also traditional ecological perspective and traditional ecological knowledge, which is really an exciting aspect of the case, as well as a Native Hawaiian mental health expert as well. So that evidence will be front, and we just got the defendant's expert reports yesterday and are in the middle of expert depositions today. Some of my team is defending one of our experts in Hilo, Hawaii today. So that is definitely a case to follow. And I think we'll set a model in terms of what government should be doing with respect to decarbonization of transportation. So that's really exciting to see that come to play.
Now, were you at transportation at one point?
I was. When I was
US.
a baby lawyer, I was a year out of law school, so a toddler lawyer.
I'm not blaming you.
I was with the Department of Transportation.
You were in the honors program.
I was in the honors program.
And by the way, the
Yep.
reason I raised that is Andrew was in the honors program, a very credentialed lawyer, clerked in Montana?
Arizona.
In Arizona. Sam, not so qualified. He clerked on the U.S. Supreme Court and worked at the Justice Department. So the reason I raise that is that, it's just a lot of these folks who have done this could probably make a mint in the private sector for almost anyone doing anything, but they have committed to this. And I really think that's pretty incredible that our Earth has really some of the finest attorneys working for it right now, because they want to and not because they need to. So thank you. All right, Sam, let's talk. Let's get you in trouble. Fair enough? No.
Wouldn't be the first time. Okay.
You know, when I worked at the Justice Department, I remember the voting rights section seemed to change its policies with every administration. At one point, it was apparently for voting rights, and then another point, it was sort of against voting rights. And it seemed to be the same people who were occupying the chairs. They just had different sort of...
Same career people,
Same
anyway.
career,
Yeah.
the careerists. So why don't you tell us a little bit about what the framework has, you know, and sort of how, who's in charge and who's setting policy at the federal level, who's the president, who's the attorney general, who are the assistant AGs, who's at transportation. How does that impact the job you're doing? Because you seem sometimes to be fighting, both of you, against every administration, frankly, but it's got to be a different fight sometimes, depending upon, and so why don't you explain that?
Sure. Well, very broadly speaking, when a new presidential administration comes in, you put in new heads of agencies like the Department of Transportation or EPA, and there's a thin layer of political control over what is fundamentally a civil service organization. And the civil servants largely don't change unless an administration tries, for example, to move them all to Colorado, as President Trump did with the Bureau of Land Management. And those folks stay in place. But that thin layer of political control is trying to redirect the policymaking apparatus of that agency. And in many ways, that's super legitimate. You want that to happen because voters elect a new president, and there should be policy change. What's interesting is that the president also inherits the policy changes made by the prior administration and is generally supposed to, you know, honor those things unless they go through specific processes to change the policy. What often happens, though, is that the Justice Department is the one defending the prior administration's policies in court, whether it's against the industries that are challenging them or, in some cases, public interest advocates who are trying to change those things or who are saying, as we did, that some of those actions were illegal. So what you get is a strange situation where you have a new presidential administration with a Justice Department that has a thin layer of political control, defending the actions of a prior administration, with which it may not have agreed. The Justice Department is a special beast in this regard and tries very hard to say, we play it straight. We defend every president's actions, regardless of which president it is. We're sort of apolitical. You know, we've had some very interesting presidencies recently, and we're a 501c3 organization, but I will say that many different things were done during the Trump administration than have historically been done. But it's a common dynamic that when you go to court, the Justice Department is in there, sometimes somewhat awkwardly defending things that the prior administration did. So that means that elections have a lot of impact in courts. And that means that in 8 or 9 months, we will have different attorneys, or at least the same attorneys, but with different political control on the other side of it. I would say it plays out less aggressively in the Justice Department than it does in the other agencies, but it's really important.
For now.
For now.
Because I think
voting is important, by the way.
The politicization of everything, the hyper-partisanship, I think. I mean, don't you think that going forward, we're going to see some of the levers of power, you know, really part of the election process in a way that it's never been, and especially, I know justice, especially to the careerists who typically would be the protector of sort of sustaining a position, an intellectually honest position. Now, I don't know that it may not be that way in the near future. It may not, at some point in the future, not necessarily in this election, but at some point, I think it's just going to be, seems to be leaning towards a more partisan machine than a justice machine.
Yeah, it's worth pointing out that during the tail end of the prior administration, it was several officials in the Justice Department who sort of held the line and said, look, I mean, I wouldn't say held the line as in successfully, but they felt very strongly that even though they were politically beholden to President Trump, that what he was doing was not okay, and they wouldn't sign on the dotted line of some of the things that were being done there. So the Justice Department, I would like to think, has historically had a high degree of integrity on this. I would not count on that. All bets may be off if some of those things change.
It's very polite. I'm married to a Justice Department lawyer, so I'll be careful what I say. I don't have a C3, however, I have to worry about. I don't think he'll make that mistake again. I don't think there are going to be any mid-level or upper-level people of justice who will protect the rule of law. I think it's going to be a sort of whatever you want, you're going to get.
Well, there is one interesting feature. When I was at the Justice Department, you walk up to the lectern in court and you say, I'm here on behalf of the United States. And when you are there on behalf of the United States, the judges feel free to kick you around as if you are the United States. So you can have whatever political feelings you want, but when you go into court and say, we've totally changed our position, we think the law means X and the law means Y, that judge is going to say, last week you were in here saying this week you're saying that, You're a lawyer representing a client. You've got to have a consistent view of the law. You can't just change this. So the courts become a significant damper on changes in the administration. I mean, Dan, you're smiling at me because you know that there's more to the story than this. We could go on forever about it, but it's not just...
We could have this discussion about the courts also.
Yes.
Andrea, let's get back. Is this one of your clients we got here?
Yes, it is.
All right, Delaney, let's get Delaney involved in this. Delaney Reynolds, right? Delaney, I'll give, well, actually, I'm not the best person. Andrew, tell us about Delaney, who is no longer a 16-year-old plaintiff. When I first heard you would be here, I was looking for a 16-year-old, and actually, you look very young, so it could have happened. But go ahead, Andrew, tell us who Delaney is. And Delaney, come back if you want to sit facing on this.
Yeah, thank you. Delaney is an incredible activist. Some of you may know her in Florida, but when Delaney was 16 years old, she wrote the first ordinance mandating when new homes are built in South Miami that they be equipped with solar. And she wrote that as a 16-year-old, which is incredible. And since then has done a number of different advocacy efforts over Florida. She's also a scientist, getting a dual JD and PhD at the University of Miami, and is a fourth-generation Miamian, if that's the right term. So knows her way around, and led a petition a couple of years ago to get in Florida. Most people don't know this because it's never enforced, but Florida right now has the strongest renewable energy goals of any state, and that's because of a petition that Delaney led on behalf of over 250 young people. So that's Delaney Reynolds.
Delaney, tell us a little bit about your experience. Before you do, I want to tell you my son has a very high score in Xbox. So while you're very impressive, he is also.
Let me start by saying I love video games. Okay, I play them more often than you would.
That was very generous of you. But
no, it's true. It's true. Thank you, Andrea, and thank you for giving me some time to speak. So, first, I want to say that while I've worked with Andrea and Our Children's Trust since I was 16 years old. I'm now 24, and I am so incredibly grateful for the work that Andrea and Julia and the entire team at Our Children's Trust does, because without their support, us youth wouldn't be able to be where we are when it comes to the environmental movement and climate litigation. So thank you. So I just want to talk to you guys a little bit about why I'm involved in climate litigation, because it is kind of an intense thing to be involved with. So my answer to that kind of thing is that we don't really have a choice. So here in Florida, at least, our executive and legislative branches have absolutely failed us when it comes to climate solutions and taking our environment into account. They have failed to protect us from the foundational causes of our climate change crisis, which is the systemic use of fossil fuel products. So it's actually pretty simple. So as you heard, I am a fourth generation Floridian Miamian, and I deeply love the nature and the ecology here, whether it's the vibrant city that we're in today, Miami Beach, which I hope you all have been enjoying, or the Florida Keys, where I grew up and spent a lot of time in my youth, or the unique and fragile ecosystem that is the Everglades. And if you get the chance to go down there, I really hope you do, because it is the only habitat of its type on the planet, and it's very special. So I'm really worried for Florida's future when it comes to our environment. The carbon dioxide and the methane that we have been pumping into the atmosphere as a result of our use of fossil fuel products has been destroying our planet, and it's putting parts of Florida, like those that I just mentioned, at the very real risk of disappearing and becoming extinct, which to me is unacceptable. So yet here in the state of Florida, our elected officials, the governor, his cabinet, our legislature, they all protect the fossil fuel companies and the electric utilities over our planet and us as citizens. And the utility companies provide virtually all of their energy to its consumers from non-renewable sources. These utilities donate lavishly to these politicians. They support them very much and spend even more on advertising about how much they love renewable energies. But that is just not the case, actually. It is all a lie. They've been in business for over 100 years, and there are 3 specific energy companies. Florida Power and Light, which has a monopolistic hold on us down here in South Florida, Duke Energy, and Tampa Electric Company. They all produce 75% of Florida's energy. And now when I tell you the statistics of how much that energy is produced from solar, you're actually going to be quite shocked. So after 100 years in business, Florida Power and Light produces just 5% of its energy from renewable energy. Duke Energy sources a pathetic 1.5% from renewables, and Tampa Electric just 7%. So in a state known as the Sunshine State, this is really embarrassing for us, actually. But they have been using every trick in the book to try to fool Florida citizens into thinking that they love renewable energies and they love solar and they're putting it everywhere, when that's just simply not the case. It's not true. And when it comes to our legislature, just last week, the House of Representatives and the Senate passed a bill that will do quite a number of things if Governor DeSantis signs it into office. So it will ban offshore wind energy, of which we have none. It will remove the terms climate change and greenhouse gases from any existing state legislation, and it will reduce regulations on natural gas pipelines and more. In an earlier draft, it actually tried to outlaw allowing electric vehicles to be charged at your very own home. So we'll see if the governor signs this into legislation. It's on his desk right now. But in a year, or after a year that was the hottest year on our planet, that's what today's Florida looks like. So it is really disappointing to live here and embarrassing, quite honest. So the answer, long-winded answer to why I'm involved in such litigation is because our legislative and executive branches have failed us, and I am hoping that our judicial branch will help me draw a line in the sand to stop the pollution and to transition us into a future of renewable energy while we still have sand on Florida's beaches before it's too late.
Thank you, Lenny. That was great. By the way, a lot of that sand is shipped in from foreign countries. They've changed the law, so now we can bring sand in because it's not our sand anymore. That was really amazing. Thank you. Before we get into questions, I wanted to pose questions to both of you. It's the same question, and we'll start with Sam, and then we'll get to Andrea, and you can mention Genesis if you want, but because it may fit the answer a little bit. But what I'd like you to talk about is sort of the future of your mission, of your job. And what I mean by that, obviously, is what do you think the possibilities are in the courts? What are you hoping to change, to prevent? What are you looking to create a standard? What do you think if you're going to be most involved in, or are you most anxious about, or you're most excited about, or you're most scared about? And you too, by the way. So Sam, I know we didn't plan a lot of these questions out, so but you clerked in the Supreme Court, so I'm expecting good things.
Well, I'm scared about the Supreme Court, and I'm happy if anybody has questions about the Supreme Court, I'm happy to talk about that. Well, look, we have 200 lawyers, 200-something lawyers at Earth Justice, and about 2 or 3 of them do this kind of litigation, and we have about 700 cases, and maybe 1 or 2 of them are this kind of cases. So the courts are about these kinds of cases, meaning cases trying to vindicate a broadly stated right to a clean environment and trying to use those to get the courts to compel the legislative and executive branches to do something different. What are those other 198 lawyers at Earth Justice doing? They're doing the grunt work of actually implementing a ton of other laws that have specific remedies available to us. And that means things like, when we have a problem with Florida Power and Light, you can go to the Florida Utility Commission and you can talk to the Utility Commission, and Tanya and her team do this all the time, to say, here are the laws that protect ratepayers. They require you to do things like consider cost and fuel stability, and these are things that require you to consider renewables as part of utility mix. You can use the Clean Air Act, the Clean Water Act, traditional pollution control laws to internalize the cost of fossil fuels so that refineries and power plants that are burning them are actually controlling the pollution and therefore actually reflecting the true cost to us. You can use litigation to force the federal government and state governments to create the regulatory structures that they were required to do under the statutes that the laws provide, so that organizations like EPA have to tighten soot standards, have to tighten pollution standards across the board. So there's a ton of kinds of litigation you can do that is very actionable, that produces results every day, and that's the bread and butter of what we do. It's about taking even laws like the IRA and bringing them into practice. So the future is really bright. It's really important. We file hundreds of cases a year that have real discernible impacts, and I think the future in that terms is bright. I don't think that courts are the full solution on this, because at the end of the day, the legislature and the executive, they're the ones with the money, they're the ones with the power to write the laws. So any sort of litigation strategy has to be paired with political communications and social strategies in order to make fundamental change. The law is a component, and litigation is a component of a successful campaign to address climate and environmental issues, but it's not by any stretch of the imagination.
Before I get to you, I want to follow up on that. You all have a legislative section also?
We do.
So it was interesting in the Hawaii and the Montana case, there was a provision that created
Both cases,
that created a mandate of some kind of right that the courts obviously or the legislature had to animate. And I guess my question is, we see that in a lot of states like Florida. I worked on the redistricting amendments for Florida, but are there a lot of states that are trying to put into their constitutions a sort of a right to a clean environment? Because as the environment gets much worse, it may become more obvious that those kinds of provisions can actually form the basis for either action or a reaction of a lawsuit. Is that something that's happening across the country?
It is happening, and the most notable success is New York's Climate Leadership and Community Protection Act, which is a law that the New York legislature passed that Earth Justice is now able to implement, and we've used it very successfully to block the development of a new gas power plant, to say, look, this is inconsistent with the specific requirements of this new law. There are also ballot initiatives that are there to consider that are potentially available to change the requirements on legislatures and governors of states. So yes, to the extent that we can get laws passed that explicitly name climate concerns as an issue, or that put greenhouse gas reduction targets, or that impose enforceable requirements on governments of the state to do things, then yes, those are powerful and those are enforceable. And if there were one thing that I would love to have more of as an environmental litigator, it's more of those specific tools to effectuate change.
Andrea, so answer the question twice before.
Yeah.
What's keeping you up? What's getting you excited? What are you worried about? And at some point, talk about Genesis, because that is it's an equal protection case. So to a certain extent, it is a kind of mandate kind of case.
Yeah, well, we're 14 years into our litigation campaign, and we really are starting to see progress. And for many of you who follow the law, you know that the law can be very slow. And law evolves in a certain way. And, we've been collecting dissenting opinions over the years. We've been collecting administrative victories. And last year was really a watershed year, with Held going to trial and getting that victory. 3 other cases green-lighted for trial in Canada, in Hawaii, and then Juliana, which is caught in a political morass. That's a whole nother story. But so I do see a shift, particularly at the state and international level, in recognizing fundamental rights of children. And one thing that people don't talk about with Held, people really focus on the right to a clean and healthful environment, but that case was also decided on individual dignity grounds and the rights to life and liberty and equal protection. Those are explicitly protected under the Montana Constitution, and that was a part of the court's decision, because the court said you can't have dignity if you don't have a safe and healthy environment in which to grow and develop. So that is starting, I think the narrative is starting to change and people are starting to recognize, and I'm hopeful that the state courts will get there. I also am concerned with our Supreme Court because I think we've gotten to a place on the court where they're not implementing the law in accordance with precedent, in accordance with our constitutional system of democracy. So I think that's very concerning. But I also have hope. Things change, politics change, so I do see progress. And then finally, I am blessed by representing people like Delaney Reynolds. And so I get to represent the future leaders, people who, will hold positions of leadership. And that definitely gives me hope because I think they understand the systemic nature of the climate crisis and that all three branches of governments play a role. I think there's a misconception that with our cases and other cases that we want the courts to come in and take over. That's not how it works. Courts can declare the constitutional right and then it gets it back in the political court so that they can make the decisions, the solutions, and the real policy decisions. But they do that not constrained by the real problem and being overwhelmingly dominated by fossil fuels, whether through lobbying or through special interests, other special interests. So I do have a lot of hope. I do think the United States is probably going to be the last place to achieve climate justice. I think other courts around the world.
We're a leader.
Yeah, other courts around the world will get there faster, and but the United States is vital to doing that. And one of our cases that you mentioned is called the Genesis versus United States EPA, and that case was filed in December. And we represent 18 young people under the age of 18 challenging the EPA's policies that affirmatively discriminate against children. They value the lives of children less than they do present generations. So that case is explicitly about children's rights and children's equality. And I think if there's anything for judges, judges have very differing views on climate change and climate science, but where there is unity is in the desire to protect young people and to protect our children. So we're hopeful that that can bring about some positive change in terms of the jurisprudence that's guiding us forward.
Thanks. Sam?
Yeah, on the Genesis case and the Juliana case, unlike some of these other cases, are federal courts cases, and that's one of the reasons why they trigger my concerns about the Supreme Court. And I came up here and I wanted to make sure everybody in this room heard two things. One is that climate litigation encompasses an enormous range of kinds of things, ranging from wetlands protections to utility stuff to pollution control, you name it. The other thing is to convey to everybody the scale of the risk that we are facing from this Supreme Court. The Supreme Court isn't just upending precedent, it is also reimagining the way in which government works in this country. And 50 or so years ago, we had a suite of environmental laws, the Clean Water Act, the Clean Air Act, NEPA, all of these laws that were passed by hugely bipartisan legislatures, signed into law in many cases by Richard Nixon, noted environmentalist. And those laws have formed the framework for what we all think of as environmental law in this country. So one thing that's happening is the Supreme Court is revisiting settled understandings of those laws and saying it doesn't mean what you thought it has meant for the last 50 years. So it's changing its interpretation of the statutes. The other thing it's doing is saying that the way federal administrative agencies work, and what federal administrative agencies fundamentally do in the environmental area, is they take these statutory commands, these broad statutory instructions, and they turn them into the specific regulations that we all live under. And the Supreme Court is saying you get a lot less deference, a lot less respect, a lot less credibility. Your expertise matters a lot less. These are fundamentally decisions for the judiciary. And going even further to say it's not even clear that the federal government, that under our Constitution, the federal government gets to regulate in such an aggressive way. These are profoundly destabilizing things that upend an understanding of federal government that started when FDR was president. So you destabilize that stuff, it's really problematic for climate.
Fortunately, it sounds like you both have job security. So first of all, we're going to have questions in a moment. So you've got somebody with a microphone. So if you have a question, we're going to bring you up there. I'm going to ask, so why don't we start that now because I see some hands going up. Thank you, by the way. We have 15 minutes, right? All right. Stand up. Tell me what newspaper you're from.
I voted for you.
So that's obviously very bright.
better.
Obviously very bright man.
You didn't ask for a show of those hands, Dan. How many people in here voted for him?
Well, I ran on a good weather platform and it was working out. Go ahead.
I'm a retired physician, and like many other retirees, I live in a condominium. What do you do as an individual when you can see issues going on in the condominium that are totally toxic to the environment, whether it be stuff to clean the swimming pool, stuff to clean the elevator, or just the overall way they treat employees? I called the EPA, and they basically said nothing I can do about it. And I spoke to somebody here yesterday, and they said, because I live in a red state, forget about it. And I don't really have enough money to hire you guys as a law firm to represent me. What do you do as an individual?
If you want to, or I will, whatever you'd like.
We don't charge any money.
That's right. They don't charge money.
Not promising anything, but
I will tell you this, though, because I served 10 years in the legislature, in the House and the Senate. I was the Democratic leader there. What they're doing in Florida, for instance, is they'll put somebody in Tallahassee in charge of condo complaints. So there's a department they've created there with 3 people, and there's 21 million people in Florida, so I'm sure he will get to you at some point and address your issues. They do that with a lot of the environmental issues also. For instance, the planning, the best way to stop any kind of thoughtful planning is to simply say, well, we're going to take care of it with 4 people in Tallahassee who will every 6 years visit the community you're in and for an hour and take care of all those problems that have been percolating. So, all right, let's get some other questions. And I'll leave it to you to decide. Although I want to get the law student up here.
Thank you. First of all, great presentation, so thank you all. I work in reality television. Right now, true crime is really hot.
So do they.
Yes. True crime is like the #1 thing that everybody's asking for in reality TV. So I'm just curious, and forgive my ignorance on this, but have you guys worked on any cases, or do you see cases happening that are actually criminally prosecuting companies or executives working at companies, and what does the future look like there? Are we going to see like oil executives in jail?
You worked, Sam. You worked at Justice.
I did. So it's a miracle of American environmental law that people can enforce it. In most countries, individual people on the street don't have the right to go to court and enforce the laws. But the Clean Water Act, the Clean Air Act, it gives people the right to do that, and that's what puts us in business. Criminal laws aren't that way. Sensibly, right? You can't decide to prosecute your neighbor for speeding or for any crime you want. That's the government's function. So in that respect, it's different. You'd have to have a government prosecutor, and Dan was a prosecutor, and a government prosecutor would have to decide to bring that case. And then you'd have to decide whether you're suing the company in its corporate form or an individual who made decisions. Both of those kinds of cases are difficult to mount, and they're well defended. And the fossil fuel industry would say, you've got to find a very clear legal law that we've violated. You've got to find a prosecutor who believes they have a meritorious case. And you got to find a jury and a judge willing to convict. It's historically difficult even to get genuine criminal convictions as opposed to civil convictions for even basic environmental harms. So I would say that it's a possibility, and there's a reason why we don't get a ton of it already. Dan can probably tell you more about that.
One thing I'd add to that is in criminal cases, very often the government is satisfied with what appears to be a very enormous penalty financially, but to the company is typically just the cost of doing business. So what you see is, and the Department of Justice has internal rules for organizations as to what, and at least it does incentivize fixing your own house and paying a lot of money and making sure it doesn't happen again, which is actually pretty good, but it does not push going to jail as often as it should, frankly, because that clearly would be a great deterrent. I mean, Enron happened, many of you remember, but not a lot since then.
When there's enough money at stake, and enough investors are defrauded, that often is that is often the trigger for somebody finally saying we've got to actually
rich victims.
Yeah, rich victims are.
And the only thing I'll add to that is internationally there are a number of organizations who are working on looking at the crime of ecocide. and whether that's actionable in different international areas. And I think we'd be remiss today, this is a Climate Litigation 101 panel, if we were not to talk about the number of climate damages cases that different states, cities, and counties have brought against the fossil fuel companies. You know, those are not criminal cases, those are civil tort cases, essentially. But I think what will happen with those cases, it looks like many of them will be headed to trial someday. But I think the evidence that will come out through those trials may be very intriguing. And whether it, you know, gets into the lane of criminal nature or not, I do think with those cases going to trial, that story and narrative will become much more, people will become much more publicly aware of the conduct that contributed to the climate crisis.
To put a real fine point on that, some of the most promising of these lawsuits, our organizations don't do that kind of litigation because this litigation often results in massive attorney's fees. It's inconsistent with our C3, with our charitable status, so we don't do them ourselves. However, there are private sector plaintiffs' lawyers bringing these cases, and the most promising of those cases or claims, I think, are the ones around fraud, saying that in much the same way as the cigarette industry was telling consumers one thing, even though it knew something otherwise, the allegations are that the oil industry was denying climate change, denying the linkages of its product to that, and that denial led these municipalities and states to end up having to spend a ton of money on effectively climate resilience. These are very interesting and promising cases, and critically, they are state law claims, and that means that they will not be reviewable in this Supreme Court. In fact, the Supreme Court has now repeatedly refused to take up the question of whether these things belong in federal court, and which in this situation is effectively saying they don't because the lower court decisions.
Yeah, and as criminal is unlikely. I'm a lawyer who represents some of the opioid plaintiffs, and it's the same thing like cigarettes. It was sort of people thought 10, 15 years ago, oh, I can't imagine that there's something there. And of course, there really haven't been criminal prosecutions over opioid, but there have been massive civil rewards from both AGs and private plaintiffs. Let's get some other.
Oh, thank you. Hi, I am a woman on e-mission. My e-mission is to get network news to my former industry, cover environment and climate news as if it's as important as other issues, if not the most important. I think I interviewed Alex Lors, 14 years ago? Was that the beginning of Children's Trust? Amazing. I have an idea to stop something that is toxic and is absolutely impeding every day our progress, and that is to sue Fox, not news, for continuing up until last night to lie about climate reality. If they cannot get away with lying about COVID or election fraud, how can they get away with this? And I think the way to get around the First Amendment is to find the many people who were Fox watchers who lost their homes, family members, because they didn't think climate change was real, therefore they didn't evacuate or evacuated time. And so I actually record all these stories, and I got names of victims in a lot of red areas. And I wonder if you think that would be a legitimate case, because everyone I've run it by says, yeah, but I haven't met any lawyers yet. So thank you.
All right. You got a client. Let's keep, I think we've got a lot of hands up, so just, oh, look, Star, I think you've got the mic.
Hi, how are you all doing today? I'm a student at George Washington University, a law student, and I was wondering if someone could give a little bit more insight about what you all see happening with indigenous communities with respect to the way the climate crisis is upending these communities and upending their culture.
Andrea, you were counsel, if I recall from your resume. Go ahead.
Yep. I used to represent Snoqualmie Indian Tribe, and then we represent a number of indigenous youth. And with Earth Justice, a lot of our clients are in the Hawaii case are Native Hawaiian. So, I don't have what the solution is other than, the stories are incredible. And I think part of the work that we're doing are elevating those stories so that they can be heard in court, as well as working with experts who can share those stories, because that's a vital part of the evidence and how they're being impacted. And then I think what's really important also is on the solution side of things, right? Because I learned yesterday from a person I met at the conference that I think it was a huge I can't remember what the percentage was, but a percentage of lithium mines are in very close proximity to indigenous lands with a number of different consequences. So I think it's really important when we are advocating for decarbonization policies, which is a big part of what our litigation is about, and we present evidence about that. We're cognizant of what that means to Indigenous communities and make sure that we include that as part of the evidence and as part of the stories as well. But that's what I can offer from my perspective. Yeah.
It's up to you guys to pick.
Hi. The EPA recently granted primacy to Louisiana's Department of Natural Resources so that it could permit CCUS facilities. It's driven a massive push for permitting more plants, more transmission lines. In Louisiana, it's proven to be a complete disaster. Is there any possibility that the EPA could be sued to reverse that?
I'm hedging because I don't know what the status. Yes, theoretically, it's 100% possible, and I might have seen the claim. I just don't know whether it's been filed yet. But yeah, it's 100% possible to challenge that. It's exactly what Tanya did on the 404 delegation, where there's a permitting program that's typically administered by the federal government that can be delegated. That's the term, delegated down to a state government. So this is the authority to permit the drilling of wells for carbon sequestration, currently held by EPA, I believe, and now being delegated to Louisiana. And in exactly the same way as EPA delegated wetlands permitting authority to Florida, and we challenged that successfully, this also can be challenged. There's a tremendous amount of Biden administration political energy being placed in delegating that authority, and I think the calculus is the Biden administration really wants to see carbon sequestration start happening, to let the IRA money flow, to start, seeing some of this stuff land on the ground. So this is an issue. This is an issue or an instance in which our concerns, your concerns, might be at odds with the current administration's policy things. So we're frenemies. Us and the Biden administration, sometimes on the same side, sometimes on the opposite. But yes, 100% able to be challenged, and I'm not sure the status of where we are.
Went from 100% possible to yes, it will be. So you made a good move today. Okay.
Hi there. My name's Tiffany Grantham, and I'm with the Ballot Initiative for a fundamental right to clean water here in the Florida Constitution. I guess my question is, do you all know about it, and will you support it? Thanks.
I'll say one thing about that, because I've spent a lot of time. I did 2 or 3 ballot initiatives, and I'm involved with the reproductive rights one that is currently being considered by the Florida Supreme Court in drafting it. Ballot initiatives are very hard in some states, and I think I want to ask you this question, and we're near the end, but I think it's worth. In Florida, for instance, it's 60%, and they are constantly creating new impediments to getting voter signatures. We had a team of lawyers on the reproductive right ones. We're still crossing our fingers in front of the Supreme Court. The path is treacherous and torturous and perilous to even get on the ballot, and then it's probably many, many millions. And if you don't have something like reproductive rights, which is something that inspires everybody's interest on both sides, it's hard. Is there hope in states that might not be particularly amenable to ballot initiatives? Most have the process. But are you all working on trying to get states that might not even be supportive of this? Montana and Hawaii. Montana's interesting. Hawaii's not as interesting in a sense that I would have expected it, like I would in California and New York. But what about Alabama, and what about Louisiana and those states? People want clean water and clean air there.
Yeah, we're actually working on that, and they do pull very well. And the challenge is the opposition messaging that requires you to spend millions and millions and millions of dollars. But many people are interested in doing that work, and we've seen a lot of the amendments and drafting them, so that it aligns with how the constitutional jurisprudence of each state is really important. But your instincts are right. In places, like Nevada or Michigan or Ohio, they do poll very well, but it is very, very expensive. And so I think, a campaign like that is worth pursuing, as well as having, not only a good litigation strategy to enforce the right, but the political and communication strategy as well.
It means fundraising.
Yes.
Sam.
Well, one of the interesting features of these is that the wording that you use for a ballot initiative in order to get people vote for it isn't necessarily the wording that you would want to have afterwards in order to make it enforceable and to do what you want. So if you're doing this, call a lawyer. Make sure that the wording does what you want it to do. Otherwise, Tanya and her team are going to be trying to explain what it means to a judge down the line to get the results that you want.
All right, we're done with the questions. I'm sorry. I want to get back to you all. We have 2 minutes, so I'm going to ask you one final wrap up. I have always said this is a surmountable challenge. I'm not sure surmountable is a word, but people seem to know what I mean when I say it. I assume you agree, but I'd like to ask you what your sort of vision of climate challenges in the courts and what you see the possibilities are going to be going forward.
I think virtually all of the changes that everybody is talking about here at this convening are changes that will be implemented through law and regulatory policy. And implementing law and regulatory policy is not just about writing the laws in the books, it's about enforcing it and driving the changes on the ground. In that respect, you're going to need a lot of lawyering, hopefully not litigation, although it often does come to that. But the role of lawyers is unfortunately going to be integral in solving and addressing the climate crisis. I wish it weren't so. I wish I were out of a job. That would be great. But the kind of work that we do is really important, and that's why I came here from the private sector and gave up all of the other potential opportunities to me. So I'm profoundly grateful for the work that the team at Earth Justice does. I'm profoundly grateful for living in a country where the democracy still, generally speaking, works and we have functioning courts.
Andrew?
Yeah, I see in 10 years, I see the majority of states having protection of a right to a safe climate. And where litigation has failed, I see the political groundswell to be fixing that problem, like you saw with Dobbs. The political what happened, that mobilized democracy. As difficult as the decision was, it mobilized democracy. So I see something similar with climate. I see courts recognizing that children have a right to a safe climate system, and I see those courts that have shut the door on children. I see the groundswell political movement coming in to support children and to make the change.
Thank you. I'll just say this. Inertia is not an organizing principle. So we all have to do a little work on this, or a lot of work. And these organizations have people in them who are incredibly dedicated, woefully underpaid. So although they didn't ask me to, they're all, I'm sure you can support them in every way. If you have a friend who's a millionaire or billionaire who loves the environment, tell them to give a bunch or just give a little yourselves. Am I allowed to say all that?
Thank you.
I think I'm allowed to say that.
Okay. Thank you all for coming.